All right, welcome back. We continue to recap a hearing today that we heard from the Doomsday cult mom, Lori Vallow-Daybell. She is facing charges involving the deaths of her two children, Tylee Ryan and J.J. Vallow. Here, defense attorney John Thomas argues about splitting the conspiracy charges. Now, this is the thing I want to talk about. I'm sure my guests are going to think I'm out of my mind, but I'm just not getting something. Let's take a listen.
Our main argument revolves around counts 1 and 3. That they're confusing to the jury. They would be confusing to a jury when they have to find this after the trial to find this these elements. And I see that the state is saying that the crimes of murder and the crime of grand theft are not necessarily the crimes in the conspiracy. However, this doesn't make any sense because the conspiracy to commit murder and the conspiracy to commit grand theft are two separate conspiracies. And I'll go through that in just a bit. But we do believe that it would be confusing to a jury to be able to figure out what elements were met and when the elements were met and to what extent the elements were met. The burden is high. The burden is beyond a reasonable doubt. If they meet some of the burden at a different standard, perhaps a probable cause standard, or perhaps a more likely than not, or a different standard, that would be severely detrimental to our client. So I think one of the things that we need to think about in reviewing whether or not these charges, conspiracy to commit murder and grand theft in counts 1 and counts 3, should be split off or bifurcated. I think we need to say when does the conspiracy end? Well, one would think that the conspiracy to commit murder would end when the alleged murder occurs. That would be the end of the conspiracy. The state has pled in count 2 of the indictment that the murder of Tylee Ryan occurred on or between September 8th and September 9th. So that would be the end of that conspiracy. The conspiracy to commit the crime would have been completed, and the conspiracy to the murder would have been over. One would think that the conspiracy to commit grand theft ended when the grand theft was over. And the pleadings in count 7 of the indictment indicate that the grand theft would have occurred after the murder. The murder of Tylee Ryan was pled to have allegedly occurred no later than September 9th. And the murder of J.J. Vallow in count 3, that murder was alleged to have been committed on or before September 23rd. And so the grand theft was alleged to have occurred pursuant to their indictment between October 1st and January 22nd. So the conspiracy, while we can have a before portion of the conspiracy,
What was the October date?
October 1, 2019, and January 22nd, 2020.
Oh, thank you.
And so they're saying that the conspiracy, while it could have possibly developed earlier, it could not possibly have ended in the same time that the conspiracy to commit murder would have ended. So the conspiracy to commit murder would have ended at the very least, at the very most, on September 23rd. The conspiracy to commit the grand thefts were committed between October 1st, allegedly, and January 22nd of the following year. And so those don't line up.
Okay, so that's the defense attorney's argument. Now, I'm not going to give the killer question yet and get ready for my guests to jump on me for this, but let's break down at least this defense argument. We'll hear the judge talking about this a little bit later on. But Bob HILLE, a conspiracy is an agreement between two people or two or more people in which and there's an overt act to commit a crime. Can you talk to us about the importance of the indictment being correct, the charges being read to the jury being correct, and the jury charges being correct? So if I'm a prosecutor and I'm listening to this, I'm getting nervous because I know one way that you can get reversed in a nanosecond is if what's communicated to the jury is that the law is wrong. So how important is this motion?
Well, I think all of this is going to center on, as we talk about conspiracy and the elements of it, as you just discussed, it's going to be factually different depending upon what the allegations are. And this is a very technical argument that you're hearing from defense counsel, saying that basically the facts for these two different counts are different and they require different things to prove. They're not the same. There may be some overlap, but they are different. And what we don't want to have here is we don't want this conflict to result, as you pointed out, in confusion by the jury in terms of what they have to decide, and where one may spill over to another, and especially if it spills over to the more serious count.
Right, and Philip, let's talk about at the end of the day, however this is going to shake out, the judge is going to be reading them a jury charge. That is the law, irrespective of what the jury thinks of the law. And currently, as I understand this indictment, the prosecutors will have to prove both a conspiracy for murder as well as the fraud piece to it, because it says and, not or. And does that not put the prosecution in a more difficult position? Does the prosecutor not want to split it up specifically so that they don't have to have a jury say, well, I think there was a conspiracy on one, but I don't necessarily think there was a conspiracy on the other? That and in that jury charge down the road could be a problem for prosecutors.
I don't think so at all. They're going to have a PowerPoint up on a big overhead for the jury that's going to lay out the elements for each act, for each conspiracy. So, for example, if it's conspiracy to commit murder against one of the children, they're going to put a date or a time that they believe the agreement to kill was made. They're also going to list what the act or acts in furtherance of that conspiracy was or were, so that it went beyond mere talk, you know? And then for the fraud or the grand theft, they're going to do the same thing. I think what defense counsel is trying to do is to try to conflate it all into one agreement, into one conspiracy. But in fact, it sounds like there were multiple agreements, multiple conspiracies per each criminal act. So the prosecution is just going to have to divide it up and itemize it for the jury, typically on a PowerPoint, so they can see item by item, blow by blow, what they have proven to the jury.
Okay, guys, so let's listen to a little bit more about the arguments in court.